This is the laws of Nigeria. The prosecution and this court doesn't know the law. That is the fact.
Yes.
Poor knowledge of the law is killing Nigeria. Poor knowledge of the law, they don't know the law. This is a federal gazetted law of Nigeria that says here that the chief judge of Nigeria cannot tell Binta Nyako what to do. It's here. It's your law. Just obey it. That is why I do what I do. I agitate for Biafra. I agitate for Biafra. My right to agitate. My right. They turned it from treasonable felony now to terrorism. Stop talking when I'm talking.
Sorry.
Told them that if they convict me, this is what happens. You can see it. They don't want the truth to come out. Nobody wants the truth to come out. Nobody wants the truth to come out of it. In a corrupt society, that's what happens. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. Disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask.
You have made your point.
Because they have no case against me. They have no case against me, and they know it.
You have adjourned the case synodized. What's the way forward?
Well, there's no way this case could have gone on anywhere. Because in the first place, the court had lost jurisdiction to sit over this case since September last year. So we came here today on a limited appearance. We appeared under protest out of utmost respect for the judge and for the court, to listen to the court as to the reasons why we were invited before the same court that was recused in September last year. Nigerian public needs to understand the nature of a recusal. A recusal comes as a court order, and even non-lawyers are aware that once an order of court is made, the only way you can sit to the side is to put it on appeal. Nobody appealed this order. The order is extant and subsisting, it's still valid, and we were invited today to be informed about some memo from the chief judge that we don't even have a copy of the memo. So our submission on the record is that the court stands recused until that order is set aside.
Now, sir, the judge, Justice Binta Nyako, has adjourned this case synodized. What is the implication for your client?
Well, synodized is a word about indefinite adjournment. So she has no business, the court, like I said before, even having the case before her today. So adjourning it, synodized or not, really, it doesn't apply. But remember that we had requested this adjournment synodized last year, but it wasn't granted.
So what happens next?
Well, it's up to the judiciary and the federal government. We are not the prosecutor, we are the defense. You throw the ball to us and we catch the ball. We cannot reinstitute the case. Let them do the right thing. Our client recused the judge, and the judge consented to the recusal through a coroner. So we await the day that this case will be recalendared before a new judge to try it. We are not afraid of trial, but we are afraid of injustice.
They told them.
The leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu, on Monday, questioned the jurisdiction of his alleged terrorism case when he reappeared before Justice Binta Nyako of the Federal High Court for the resumed hearing of his protracted case. Despite Kanu's insistence that Justice Nyako has no jurisdiction over his case, the judge adjourned the matter indefinitely. Kanu was brought into Nigeria in June 2021 and has since been detained and tried for alleged terrorism. His trial was stalled after Justice Nyako recused herself from the case following an oral application by the defendant on September 24, 2024. The IPOB leader had directly told the judge that he no longer had confidence in her handling of his trial. However, the Chief Judge of the Federal High Court, John Tosho, reverted the file to Nyako on the ground that Kanu's application must be brought formally before the court through a motion on notice. Consequently, in a letter dated December 5, 2024, addressed to the Deputy Chief Registrar, Adegboyega Awomolo, the prosecution counsel asked the court to fix a date for the commencement of the trial. Opposing a request for a trial date, the defense counsel, Aloy Ejimako, in a letter dated December 9, 2024, said the ruling of the judge recusing herself remained valid. Subsequently, Ejimako asked that the case be transferred to a federal high court in the southeast if no judge in Abuja is willing to preside over it. His prayer, however, did not see the light of the day. At the resumed hearing on Monday, February 10, 2025, Justice Nyako said the Chief Judge had not accepted her recusal and had referred the case back to her. She asked the defense team, led by Ejimako, to come up with a written application if they still insist on the recusal. Earlier, the prosecution counsel, led by Adegboyega Awomolo, said they were ready for the commencement of trial as his witnesses were ready. Addressing the court, a furious Kanu questioned why he was brought before Justice Nyako. He said all that the judge said was meaningless to him. He said he does not recognize the authority of the court presided by Justice Nyako over him. The IPOB leader said it was only in court because of the respect he has for the rule of law, adding that the judge had previously recused herself from the case. Kanu said he was not happy with the decision of the Chief Judge, who returned the case to Justice Nyako, insisting that the prosecution cannot prosecute him. The IPOB leader insisted that Justice Nyako is biased over his case and should not preside over his case. He said poor knowledge of the court is affecting Nigeria. The prosecution counsel took an objection to Kanu's remarks and asked for a definite date for hearing, since the prosecution has refused to file a written application. Awomolo said it was not right for Kanu to insult the court. Despite Kanu's objection, Justice Nyako adjourned his case indefinitely.
Nyako said today, for the simple reason that she has no jurisdiction to. None whatsoever. I came out of courtesy and respect. She stands recused from my case and cannot try my case. There are things that are happening in this country that a lot of you do not know. It is my duty to make that very, very clear to all of you today. Because the lies are too much. The lies are too much. I sent a petition to NJC. I don't want to talk about it. Justice Binta Nyako is using her position for personal gain. For personal gain. Her son and her husband are facing corruption charges. And they told them that if they convict me, this is what happens. You can see it. They don't want the truth to come out. Nobody wants the truth to come out. Nobody wants the truth to come out. Nobody wants the truth to come out in Nigeria. That's the problem. Who is that person? Corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing. It doesn't matter if they off it. In a corrupt society, that's what happens. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask. Because they have no case against me. They have no case against me, and they know it.